My lady and my lords, before lunch I dealt with the question of similarity in the sense of, is an appeal against a VAT assessment similar to the appeals against assessments to income tax, etc., that I've referred you to. Now I'm going to address the question of what should happen where there is more than one similar domestic action. Because in this case, whilst I say that the direct tax, income tax, capital gains tax, corporation tax, and the SDLT appeals are similar, it is common ground that there are a number of other indirect taxes besides VAT that are subject to the hardship requirement, or prepay unless you can prove hardship. So we have some domestic law actions treated in the same way, and we have some that are treated more favourably. The question is, what does EU law require in terms of equivalence in that situation? Well, my submission is quite simple, and I've already referred to it a number of times when taking you through the case law. Equivalence requires the claimant or the appellant to identify a similar domestic action and show that it has a more favourable treatment, and if it can do that, then the principle of equivalence is breached.
Any equivalent action will do.
A similar.
So any similar one. I mean,
the similarity is the key filter, my lord. And it has to be similar for the purposes of the treatment in question.
But if there's a single tax which is more favourably treated, that's good enough, irrespective of the particular respect in which it's more favourably treated. Is that correct?
My lord, by definition, if you've come to the conclusion that it's similar, you've considered similarity for the purposes of the treatment in question. Because that was the thrust of my submission this morning, that you've got to look for similarity for the purposes of prepayment. So by definition at this stage, you've already decided for that purpose, these two actions are similar, which then begs the question, well, why should we treat them differently? Why should the EU law action not be treated in the same way as the domestic law action?
Well, I wonder whether you don't invite another artificial result by separating out the two processes in that way.
There's not two processes, my lord. There's one process, decide similarity in the context of the treatment in question, and then assess whether it's treated more favourably. Unless my lord is saying that deciding whether or not it's treated more favourably is a separate process. You're simply deciding, is it similar for that purpose? And if it is, then why shouldn't it be treated in the same way?
I remind myself that your first submission is that effectively any tax appeal is similar. So that my lord's question, well, if you can find one tax in which the regime for an appeal doesn't require payment up front or is more favourable in some way, then the principle applies.
Yes, I mean, and that is borne out by the case law and indeed the reason behind the principle. So in terms of the case law, I've referred you this morning to the Leves case and the Ponting case, both of which say it's for the national court to look at whether one or more actions are similar, and if one or more are similar, to carry out the comparison. So the court itself is saying you look at the full range. In terms of the underlying principle, I've also shown you this morning that the principle of equivalence is based on the principle of non-discrimination and equal treatment. This court accepted that in FA Iraq. The court itself has said it in Rietzma and in Pasquini, which is another case I might show you in a moment. If, or given that the underlying principle is equal treatment, if I can point to another similar, relevantly similar domestic action that's treated more favourably, then the principle of non-discrimination is not satisfied because something is being treated more favourably without justification. And that is what equal treatment means. It means treating things that are the same in the same way unless a difference in treatment is justified. So my starting point is the simple proposition that you need to identify similar action and show that it's treated more favourably. And that is the approach of the court in Stringer. That's the way the question was framed there. It's the approach of this court in FA Iraq. That's the way the question was posed there. There's 4 points in support of that. The first is that the case law of the Court of Justice confirms that the claimant is entitled to identify one or more similar actions, and the court must consider each of those to see if they're treated more favourably. And as I just referred, that's Pontin, paragraph 56, and Leves, paragraph 50. I also say, as I did this morning, that the Supreme Court decision in FA Iraq supports this proposition, because in that case, a domestic action was treated in the same way. That's the Human Rights Act claim, was treated in the same way, but that was not an answer. The court went on to consider similarity with the more favourable asylum claims appeal.
Well, we've expressed a certain reservation about relying on that.
Yes, my lady.
Particularly as the appeal was subsequently withdrawn,
Yes, my lady.
as I have ascertained by consent.
Yes, thank you,
So
my
there's
lady.
actually no determination by this court, or indeed by, as far as I can tell, by anybody else. So it's not authority for anything.
I know that, my lady. I mean, I would simply point out that the court didn't know that when it was setting out its judgment, and would have thought that it was deciding.
Oh, you can rely on what was said in it, but you can't rely on it as authority for anything.
Oh, I take that point, my lady. The second point is, if it were correct that claimants were entitled to nothing more than equal treatment with the least favourable similar action, there would be no need to specify a most favourable proviso. I'm going to come on to what exactly that most favourable proviso means, but the very existence of that, you don't get the most favourable, whatever that means, implies that otherwise you are looking at the full range and you're entitled to comparisons with the most favourable. The third point, which I've already made in the context of dealing with my Lord's question, is that the underlying purpose of the principle is equal treatment. Now, the court has seen Rietzma this morning. The court saw FA Iraq this morning. One case I might just quickly show you one paragraph in is the Pasquini case, which is behind tab 26, beginning at page 915.
Tab 36.
26, my lord.
Did you say 913?
It begins at 915, my lady, and the paragraph I want to show you is on page 938, and it's paragraph 70.
Sorry, page?
938, my lord, paragraph 70. And it's the point in the middle of the paragraph, the principle of equivalence, which requires that two comparable situations, one of community origin and the other purely internal, should be subject to the same procedural rules, is in fact simply the expression of the principle of equal treatment, which is one of the fundamental principles of community law. And it is no answer to a claim for equal treatment or complaint about discrimination to say that, well, I also discriminate against this other person. Equal treatment seeks to attain a level playing field for all. And so as long as there is another cause of action that is similar, which is treated more favourably without justification, the principles of equal treatment and therefore equivalence are not satisfied. The fourth point is to deal with some of the remarkable results that the Court of Appeal raised at paragraph 48 of their decision, which, although in the context of the most favourable proviso, would apply to my submission right now. So that's the Appeals Bundle, tab 7, page 105. So the points made by the Court of Appeal there, the first point is it would be remarkable that EU law claims are propelled to the top of the queue. That, in my submission, is no more than assertion. Either that's what the equivalence principle requires, in which case it's not remarkable, or it isn't, in which case I'm wrong. But to say it's a reason against my interpretation, I submit is not correct. It's just either the consequence of the interpretation or it's not. It's also, as I've just submitted, how the principle of equal treatment and non-discrimination operates. The second point the Court of Appeal makes, which it refers to as first, fourth line up, first, as just stated, procedure is a matter for the national court. Well, that's not correct. As I've shown you, the Advocate General described this as a margin of appreciation or a margin of discretion, and it's always subject to the principles of equivalence. So we get nowhere by saying procedure is a matter for the national court when we know that procedure is a matter subject to the principle of equivalence. So it always begs the question, well, what does equivalence require? It doesn't get us anywhere. Second, equivalence does not seek to raise the standard of procedural rules to the highest. See, for example, Parmigiani and Stringer above. Well, my learned friend can take this point further if he wants, but in my submission, those cases don't stand for that proposition. The court just says see above, but doesn't give us any paragraph references to what we might see within those decisions. And then third, it would produce considerable uncertainty in domestic law. Well, that's the effect of EU law principles whenever they operate. I mean, this court will be familiar with all sorts of cases where people have sought to get to the top of the queue or to achieve a better result than on domestic law using EU law. So the uncertainty is part and parcel of EU law general principles. So for those four reasons, my submission is that where there is more than one similar action, the claimant is entitled to draw a comparison with any of those similar actions and ask whether that one has a more favorable treatment, and if it does, to seek that more favorable treatment. Then we come on to the most favorable proviso, which is how the Court of Appeal purported to decide this appeal. I've already made 2 points on the most favorable proviso. The first is that, as far as I can see, I'm willing to be corrected, there is no case where the most favorable proviso has been applied by the Court of Justice. None that I've found, anyway. The second point is that, as far as I can see, it's never been elaborated upon by the Court of Justice. Rather, we have to infer the content of the rule from the way it's used or not used in practice.
And is there no commentary on it in the textbook?
Nothing that shines a particular light on it for this purpose, my lord. I certainly have had a look, and my learned friends, I'm sure, have looked as well. There's not a huge body of academic commentary on the general principles. There's Tridamas general principles. Besides that, it's a very deep area of analysis.
So you've got 3 points. It's not applied by the court, it's not elaborated by the court, and the third one must be that you just look at the circumstances in which it's not used.
You have to infer the content from the way it's used or not used, my lord.
But your whole point is it isn't used, so...
Yes, exactly. So that's what I'm
so
saying.
You're inferring from... The third point is really you're making an inference from its non-use.
Yes, my lord.
Yes.
The Court of Appeal, paragraph 47, page 105. And I showed you this earlier, but I just want to show you how the Court of Appeal interpreted the most favorable proviso. And I'm going to set out my criticisms of that interpretation. So, as we saw before, Lady Justice Arden accepts the equivalence principle, shares the same jurisprudential root as the equal treatment principle, but that does not mean that it has the same incidence. The jurisprudence of this Court of Justice shows that it is open to a member state to apply any available set of rules which are already applied to similar claims to an EU-derived claim, provided that an EU-derived claim is not selected for the worst treatment. No one suggests that's the position here. So the Court of Appeal starts with a proviso that says you're not required to extend your most favourable rules, and ends up with a gloss on that saying do not select for worst treatment. And my first point is that it's impossible to believe that when the Court of Justice says it's not necessary to extend the most favourable rules, what it's really saying, and what the Court of Appeal has discerned, is that do not select for worst treatment. That is a matter of framing a rule of practice, is liable to mislead. The second point is that actually the Court of Appeal's interpretation is, I say, contradicted by the case law. In Pontin and Leves, as I've already said a number of times, the search was for similar actions with more favourable treatment, not similar actions with the same treatment. In fact, there is no case where the court has carried out a search for something with the same treatment, which logically it should be doing. So that was the second point, contradicted by the case law. And the third point is one I've already made and won't repeat at any length, which is that given that it is based upon the principle of equal treatment, do not select for worse treatment would be inconsistent with the underlying basis of the principle of equivalence. So, if I'm right that the Court of Appeal's interpretation, the most favourable proviso, is wrong, that leaves the question, well, what does the court mean when it talks about this most favourable proviso? Well, it's potentially relevant at two stages, I say, of the analysis. First of all, it is the flip side of the need to identify similarity. And what I mean by that is the court is saying you cannot simply go out and find the most favourable limitation period in the legal system without considering similarity. And that, if you look at EDIS, could be what the court is saying. So EDIS is in the volume 4 of the authorities bundles, and I'll just show you one paragraph again, if I may. On page 13 of volume 4, and so as the court will recall, what the claimant had done in this case is they needed a 10-year time limit because they wanted in 1996 to go back to 1986, and they found a 10-year time limit existing for disputes between private individuals. And they said, well, that's the time limit we want to apply to our claim for overpaid charges. And the court says at 36, observance of the principle of equivalence implies for its part that the procedural rule at issue applies without distinction to actions alleging infringement of community law and those alleging infringement of national law with respect to the same kind of charges or dues. That principle cannot, however, be interpreted as obliging a member state to extend its most favourable rules governing recovery under national law to all actions for repayment of charges or dues levied in breach of community law. So, most favourable rules governing recovery under national law is not, on its face, restricted to similar actions. It's simply saying that you cannot just go out and find the most favourable time limit in the whole of the legal system and apply it to your case. That's not what equivalence is doing, which is what EDIS were trying to do. They just found the best time limit and they were trying to apply it.
Well, is that right? Because that principle cannot be interpreted, etc. They're referring to the principle.
Of equivalence.
Well, exactly. They're referring to a situation where the charges are of the same kind.
My Lord.
See the previous sentence.
It depends.
So they're qualifying that, aren't they?
My Lord, in my submission, they're setting out 2 points of elaboration on the principle of equivalence. So The first point is that the principle of equivalence implies something, then they tell you what it implies. And what a principle implies doesn't mean that that implication becomes the entire content of the principle. It's just one incident of the principle. That's point one. And then it's saying, and another thing, the principle of equivalence does not require you to...
Well, I mean, perhaps one shouldn't engage in a sort of process of quasi-statutory construction, although maybe EU judgments lend themselves better to that than English ones. But on the face of it, that last sentence is a qualification on what's gone before. The principle, however, cannot be interpreted, etc. That's, I mean, and the other formulations of this particular, of the no most favourable rule, say the same.
Well, they're slightly different, as we saw in Leves, the references to in the field of employment law. But here, in the context of the statement, it's saying most favourable rules governing recovery under national law. It's not saying most favourable rules governing similar actions under national law. It's just under national law. And we know as a matter of fact...
If they're not similar, then the proposition stated in that second paragraph is completely irrelevant. What's the point of saying it? Because the principle would never apply anyway.
But it's the flip, that's what I'm saying. It's the flip side of the need to identify similarity. The court is emphasising the need to identify similarity.
Yes, once you've identified similarity, that won't get you home if you are relying on the thing which they're saying you can't assert in that last sentence. They're assuming similarity, and they're saying even so, you can't oblige a member state to extend its most favourable rules. I mean, it looks as if what they're getting at is some kind of suggestion that you can't select as your comparator some uncharacteristically favourable, some outlier. You've got to look more generally at the characteristics of the rule which is applied to the generality of cases. It's very vague and difficult to interpret, but that seems to be the idea they're getting at.
My lord, then that's the second point, which is that it's applied as a second filter. And that's the way Lord Neuberger interpreted it in the Stringer case. You recall at paragraph 81, he refers to it referring to exceptional or unusually beneficial rules, which would seem to fall in line with my lord's suggestion of uncharacteristic rules.
Yes, but I mean, but what I am sceptical about is your suggestion that the principle of equivalence entitles you to choose any similar proceeding that is more favourably treated, because that seems to be the precise proposition that is rejected in these paragraphs. The difficulty arises in working out where you draw the line, as to which none of these cases give one any guidance at all.
My lord, I agree, there is no explicit guidance, but it's odd that if the principle is a very broad principle, as the Court of Appeal interpreted it, and HMRC advanced it, then why isn't it applied? And why can't we find a case where it's clearly applied in that way?
Well, this is the accident of litigation.
Can I just be clear that I understand what you're saying? On the last sentence of paragraph 36, it's comparing the most favourable rules governing recovery under national law with all actions for repayment of charges or dues levied in breach of community law. Are you accepting that the first part, the rules governing recovery under national law, is dealing solely with similar cases, or is it dealing with the generality of private law claims?
My lord's point, and I accept it, is it's not clear. There's two ways you can interpret this.
I mean, because in the next paragraph, 37, there seems to be, it's surely clearer that they're there dealing with the contrast between claims between private individuals for recovery of sums paid or not due, and special rules governing claims to challenge the imposition of charges and other levies.
Yes.
But isn't that the same idea that they're doing in second sentence of paragraph 36?
No, because the point in 37 does not depend upon any analysis of whether the rules that happen to apply to private individuals are the most favourable rules. They could be, or they might not be, but the court, that's not important to paragraph 37, or indeed to paragraph 39, which is the answer to the case.
I just thought the word thus implies that 37 is intended to explain or...
My lord, well, if
36.
you start at paragraph 35, that's where the court begins its analysis of equivalence as regards the latter principle, which is equivalence, and then it goes on. So you could read the thus as referring to what has gone before, or you could read it as referring just to the preceding paragraph, or indeed the final sentence of the preceding paragraph. But I think we're going to struggle to settle that particular dispute, my lord. But what I would say is that if the court is saying that reasoning, that you cannot compare private actions between private individuals with actions to recover levies or charges, only applies where the rules applying to private individuals are the most favorable rules and not otherwise, well, why doesn't it say it at 37 or 39? Instead, my interpretation that I advance to the court is that what the Court of Justice is saying, they're not similar. It doesn't matter if it's the most favorable rule, an intermediate favorable rule, or even the same. They're just not similar. You cannot draw the comparison. And going back to my lord's point about, well, where do we draw this line? Given that there is this second filter, where is the line to be drawn? Well, Lord Neuberger said if the rule is exceptional or unusually beneficial, and that, as I've submitted, form part of the ratio of Stringer. So unless this court is going to depart from it, that is the principle that should be applied. And there is nothing exceptional or unusually beneficial about not having to pay the tax before your appeal is heard. If a more broader inquiry is to be undertaken, well, it's not clear what principles would guide that inquiry. And as has been commented upon a number of times, the case law doesn't help you, because in none of the cases before this court has the court specifically, or even inferentially in my submission, applied the most favorable proviso. You have got cases where the de facto most favorable rule was applied. I've set that out in my skeleton argument at paragraph 18. So in Byrne and the Motor Insurers Bureau, the untraced drivers agreement, 1972, had a 3-year time limit. For claims against traced drivers, Section 28 suspended time during the claimant's minority. That was the de facto most favorable rule, but that is what the Court of Appeal granted. In Transportes, Urbanos, the de facto most favorable rule was not having to exhaust alternative remedies, but that is the treatment the Court of Justice granted. In FA Iraq, the treatment sought was treatment on a par with the asylum claims, allowing you to bring an appeal. That, as far as I can tell, was the de facto best treatment. In Littlewoods, again, they were seeking the de facto best treatment. So just to summarize my submissions on that, and if the court's against me on the possible interpretation of paragraph 36, and it just applies as a second filter, then Lord Neuberger in Stringer is the guiding authority on that. It requires exceptional or unusually beneficial rules.
Yes, but in either Byrne or Transportes, were there a range of possible comparators?
I don't believe, no.
No. So can we take very much from the fact that there was one comparator which was better?
We can, my lord, if the suggestion is you do not get the most favorable treatment, full stop, and you then have to work out what the de facto most favorable treatment is, then even if you've only got one comparator, by definition that one comparator has the most favorable treatment.
But it's also the worst treatment. I mean, the expression means nothing in that context, because there's nothing to compare it with. I mean, if there only is one, it is either the worst. You can say it's the worst, you can say it's the best, but that tells you nothing. And I really don't know how Burns and Transporters are going to help us in this regard.
Well, my lord, then I refer you back to Stringer, where the rule or the principle that it's exceptional or unusually beneficial rules is set out by Lord Neuberger. It's part of the ratio of the case. and it wouldn't be engaged in this case.
I mean, I wonder if it's not sensible simply to go back to the very first principle and ask why we have a principle of equivalence at all. The reason, presumably, is that national law should not put impediments in the way of the exercise of EU legal rights. Now, the mere fact that there are one or two legal proceedings which have more favourable rules regarding limitation or some other procedural point is not in itself enough, I would have thought, to constitute an impediment in the way of exercising an EU legal right. It seems to me there is an overlap between the principle of equivalence and the principle of effectiveness, and that the somewhat mechanical way in which you put it, in which you say, well, you knock off the extraordinarily favourable ones, you look at all the others, and you've got to have the very best of those. We're moving a long way from the basic purpose of having a principle of equivalence at all.
Well, my lord, the principles of effectiveness and equivalence are separate, and there are cases where effectiveness is satisfied, but equivalence is not satisfied.
Well, I said that they overlapped. I wasn't suggesting that they were the same.
I understand that, my lord. But, my lord, then I've shown you the authority that says actually it's rooted in equal treatment and non-discrimination.
Well, that can't be right without qualification, because EU law doesn't say that there's anything wrong with giving relatively unfavourable treatment to purely domestic causes of action. It only says that there's something wrong with giving unfavourable treatment to EU causes of action. Now, this is a long way from a principle of equal treatment of the kind that you find in general discrimination law. This is a specific principle designed to rescue EU law causes of action from some peril. We might do well by asking ourselves what that peril might be.
My lord, but if you take the more limited approach, then the principle is open to abuse. For example, the taxes relied upon by HMRC, insurance premium tax, climate change levy. I mean, how many appeals on those matters are made each year? The numbers are tiny.
Well, that's a different point.
But it's well, the point is, my lord, if you say, well, as long as something's treated in the same way, equivalence is satisfied.
Well, I don't think the point I was putting to you necessarily leads to that conclusion. Seems clear to me that the case law of the CJEU is envisaging that there are some circumstances in which the mere fact that there is a more favourable procedure available for something else that is similar doesn't get you home. And I was simply suggesting that one may actually have to try and decide where you draw the line by reference to the underlying purpose of this principle. I think it is, in some senses, a principle of equal treatment, but not in the classic sense in which I think you're interpreting it.
Well, my lord, I've shown you the authorities on that point. If my lord is interpreting them in a different way to the way I am, then that's...
I'm just trying to make sense of the factual context in which these authorities were uttered, because it doesn't, their removal to a different context sometimes produces a nonsense.
Well, Rietzma, we went through in quite some detail. That was specifically VAT, and the court didn't draw any distinction between non-discrimination, equal treatment, or equivalence. If, as my lord's saying, actually equivalence is some sort of weakened form that gets you so far but not to the most favourable, then the court hasn't said that, save insofar as one interprets the references to most favourable rules in that way, but it's just...
Well, that's what I'm doing.
Exactly, my lord, but it's adding something that isn't in the case law at the moment and isn't supported by the results in the cases.
But it's all about procedural rules, which of course is very different from most equal treatment, which is about outcomes, substantive outcomes. So one does have to look at it in the context in which we're actually asking ourselves the question. And general statements by the Court of Justice that this is an aspect of the principle of equal treatment, that's fine, that's not a problem, is it? But the principle of equal treatment, as you know, I'm sure, just as well as anybody, is one of the most difficult to apply as all discrimination law shows us. So it's not surprising that we're having difficulty here, but it's not necessarily going to be appropriate to try and incorporate all the principles from equal treatment law into this particular aspect of it. That's the point you're making. But you haven't got a great deal.
I know, my lady.
In
fact, I've made my submission.
You're nearly there, aren't you?
I'm pretty much there. All I've got to deal with is the binding nature of the decision in Stringer, which is a 5-minute job, which is
What you've got.
which is exactly what I've got. Yes. So
just before you do, can I ask you this? Correct me if I'm wrong, but generally speaking, the principle of equal treatment is kept under control to some degree by justification.
yes.
Now, there hasn't, I think, been any mention of justification as a way of keeping this principle under control. And I'm wondering whether the equivalent in the context of this principle is a quite careful look at whether there really is true similarity.
That's exactly it, my lord. That was the purpose of my submissions this morning, which is when you're looking at similarity, you're looking at similarity for the purposes of the treatment in question.
Yes.
But you're also looking at similarity for the purpose of deciding whether any differences are relevant, and justification is critical to that.
That was the reason I was heading in that direction.
Absolutely. My submission fully accepts that if you can justify a difference in treatment, then the way that fits in is lack of similarity.
But that suggests, doesn't it, that because there's no separate principle of justification here, what might appear to be a justification argument in another field would entitle one to take a quite rigorous view about similarity in this context.
Well, of course, justification only arises in cases of indirect discrimination.
Indirect, yes.
Doesn't arise in direct discrimination.
Direct discrimination, it isn't discrimination, it's justified.
Just to take a practical example, if one could think of some sensible reason why
Lack of similarity is often
an appeal in relation to one tax could rationally be dealt with differently from an appeal in relation to another tax, that would strongly suggest they're not comparable for the purposes of the application of this principle.
Yes.
Yeah.
And that takes us back to the point this morning about are you sitting on the tax, because that's the justification suggested. If I may just very quickly deal with Stringer then. Court of Appeal, page 105, paragraph 46. Totel argues the equivalence principle is a facet of the equal treatment principle, so that the no most favorable treatment principle must have a field of operation restricted to exceptional or unusually beneficial rules. Mr. Firth finds that restriction in the passage from the speech of Lord Neuberger and Stringer, set out in paragraph 17 above. In my judgment, it is quite clear that the holding must be read in the light of this Court of Justice jurisprudence on which it is based, and there is nothing in the cases shown to us to support a restriction of the kind for which Mr. Firth contends. So, it's unequivocal that Lord Neuberger does say exactly what I submitted he said. The question is, then, has the Court of Appeal come up with a good reason why it's not bound to follow that interpretation? And the reason suggested is, well, you've got to read what Lord Neuberger said in light of the Court of Justice jurisprudence. Well, that's all very well, but it doesn't mean that Lord Neuberger was wrong or didn't mean what he said. It's perfectly plain.
How many of the other members agreed with him
Everyone.
on this particular point?
Well, on equivalence, well, there were, I'll
He
show you.
wasn't the lead judgment, was he?
There were two lead judgments, Lord Walker and Lord Neuberger.
Yes.
It is ratio, my lady. I can show you
Well,
that.
you told us it was ratio, and we'll make up our own minds about that, but I just
Of course,
want to know
my
how many people had...
I'm not sure Lord Walker expressed his agreement because he wrote a substantive judgment, but Lord Brown, Lord Roger, and Lord Hope all did, my lady.
The other three agreed with both Lord Walker and Lord Newberg.
Exactly.
But its practical effect may very much depend on how one applies the principle of exceptionality. That's a pretty imprecise concept as well.
It is, my lord, but the Court of Appeal rejected any concept of exceptionality, and that's the problem I'm focusing on in my third and final submission, which is the Court of Appeal should have followed Lord Neuberger, even if they said something along the lines of, well, exceptionality is context-specific and we're going to apply it in a very narrow or whatever way. But that's not what they did. They rejected the submission. They shouldn't have done. They were bound by it in my submission, and that's why there's an error of law at paragraph 46. There's a couple of authorities.
I find it very difficult to apply that test to a circumstance when there's a range of rules from 1 to 10, the least beneficial to the most beneficial. Where in that range do you say, well, this is unusually beneficial? It's not something that gives us much of a peg to hang a decision on.
My lord, you might say the same thing about similarity. There's always going to be a value judgment, and
Yes.
you've got to draw the line somewhere. But
it may mean that when one is drawing the line, one has to think very carefully, as Lord Sumption says, about the aim behind the principle.
yes, my lord. Unless I can be of further assistance, those are the submissions for the appellant.
You've been very, very helpful, Mr. Firth, and you've kept it precisely to time despite everything that's been thrown. So thank you very much indeed.
I'm grateful, my lord.
Mr. Swift.
My lady, the Commissioner's position in this appeal remains as summarised at paragraph 5 of the written case. There are 4 points there. I'll repeat them just by way of introduction. Firstly, the first submission, that there is no relevant similar domestic action. That is to say, the conclusion of Mr. Justice Moses in Marks and Spencer is correct. VAT appeals are not, for the purposes of the principle of equivalence, comparable with other tax appeals. Second submission, that in any event, there is no proper comparison between VAT and either income tax or stamp duty, land tax, or, for that matter, corporation tax or capital gains tax.
Between points 1 and 2.
Well,
It's another way of putting the same thing.
I think one is saying VAT is sui generis.
Yes,
And can't be compared with anything.
yes.
You're saying if it's not sui generis, it certainly can't be compared with SDLT or income tax or CGT.
Thank you.
So it could be compared with other indirect taxes, but not necessarily with...
Well, yes, for the purpose of the second submission, it accepts obviously the first submission is on this basis wrong. Certainly, we say no proper comparison with the taxes that Totel rely on. We also say, in any event, no less favourable treatment, which comes to the very first point that Mr. First dealt with this morning. The final submission is in relation to no most favourable treatment, and for those purposes, my lady, the proposition is that, well, even if you do not accept the submission that VAT is sui generis, it is at the least similar to the other indirect taxes identified by the Court of Appeal. And again, it's not in dispute that there is a relevant similarity applying Totel's principles as between VAT and those other indirect taxes. And that in those circumstances, the no most favourable treatment proviso applies in any event. So that is the range of the Commissioner's submissions. But before I deal with those submissions in more detail, I'd like to start with some more general submissions, firstly on the nature and the purpose of the principle of equivalence, and then by reference to the case law of the Court of Justice, which I say makes it clear that the Court draws the notion of similarity in a very narrow manner. Firstly, in relation to the nature, the purpose of the principle. As this Court is well aware, the Court of Justice uses the consistent formula to describe the content of the principle of equivalence by reference to the application of procedural rules that are not less favourable than those governing similar domestic actions. The principle of equivalence, in my submission, therefore fills an important but limited function. It is a form of minimum procedural guarantee, provided for, of course, in the context of the general freedom that is allowed to member states to identify which courts and which procedures should apply to cases brought before their court systems. The principle ensures, I say no less but no more, that claimants asserting claims based on EU law rights are in the same position as claimants pursuing similar claims based on national law, and in that way it prevents EU-derived claims being subject to less favourable treatment because of the origin of those claims. But beyond that, the principle does not seek to prescribe the procedures that should apply to claims that originate from EU law. My lady, before I go further, could I take you to a passage in the judgment in Pasquini? You've gone to this judgment briefly before. This is to a different passage. It's volume 3 of the authorities, tab 26, and the judgment starts at page 915. And when you get to 915, the relevant part I'd like to take you to in the judgment is paragraph 57, which is on page 935. So the 3 paragraphs there, 57, in accordance with the principle of equivalence, the procedural rules governing such cases must be no less favourable than those governing purely internal situations, see to that effect Palmisani and Edis. Otherwise, there would be a breach of the principle of equal treatment for workers who have exercised their right to freedom of movement and those who have spent their entire working life in a single member state. My lady, bear in mind that this case concerned the treatment afforded to a pensioner who had worked in various different member states rather than simply in Italy in the course of his career. Paragraph 58, in accordance with the principle of effectiveness, those procedural rules must not render virtually impossible or excessively difficult the exercise of rights conferred by community law, reference again to Palmisani and Edis. It would be contrary to the principle of equivalence for a situation arising from the exercise of community freedom to be classified or treated differently from a purely internal situation when they are similar and comparable, and for the situation of community origin to be subjected to special rules less favourable to the worker than those applicable to a purely internal situation. The only reason being that difference in classification of treatment. So that is to say, the only reason being that the fact that it is a situation of community origin. My lady, I say that those paragraphs, amongst other things, make clear the point suggested by my Lord Sumption. There is an interlink for these purposes between the principle of effectiveness and the principle of equivalence. And, my lady, that link, I say, is also evident in the no most favourable treatment proviso. That, of course, is a long-standing, again, part of the way in which the principle of equivalence is formulated and described by the court, is a further matter that emphasises both that the principle of equivalence is a minimum standard and also that the principle is concerned with less favourable treatment of EU law-derived claims because of the origin of that claim. And I say that for this reason. Assume a situation where there are 2 or more similar domestic actions, and assume that each of those domestic actions is subject to different procedural rules. And again, assume that the EU law claim is treated comparably to one, but is treated less favourably than the other domestic claim. In that situation, I say that there is no room, or indeed very little room, for a conclusion that the treatment that is afforded to the EU law claim is afforded to it because it is an EU law-derived claim. Any such inference is displaced, in my submission, by the fact that there are some similar domestic law claims that are treated for procedural purposes in the same way. The other characteristic of the principle of equivalence that again underlines the fact that it is a minimum standard is that the principle does not assume that in all cases there will be any similar national law claim. And so the principle accepts that if there is no similar national law claim, well then the principle has no practical application, there is no comparison to be drawn, and no need, as it were, to put the EU law claim in any form of lockstep with any other domestic claim. So in my submission, the notion of non-discrimination that the principle of equivalence requires is defined in a particular way by reference to these characteristics in order to take account of the general procedural autonomy of member states. So that is to say that the purpose, as suggested by my Lord Sumption, is directed towards the aim and objective that the pursuit of EU law-based rights should not be subject to particular difficulty. In this case, the principle of effectiveness, by reference to, as it were, a once and for all standard, although set at setting a high bar by reference to the standard of virtually impossible or excessively difficult. The principle of equivalence, by looking to the treatment in procedural terms afforded to similar domestic law claims. So between them, they identify, as it were, a flaw which will operate for the benefit of litigants before national courts seeking to enforce EU law-derived rights. That, I say, in brief summary, is and identifies the purpose pursued by the principle of equivalence. In relation to the notion of similarity, which is a point that has loomed large in the course of this morning's submissions, as pointed out by this court in FA Iraq, in the judgment of Lord Kerr, and this is paragraphs 40 to 41. I'm not sure that you've been taken to those precise paragraphs. Perhaps I can invite you to go there now, my lady. It's in volume 1 of the authorities. It's tab 3. The report starts at page 253. Paragraph 40 is on page 265. At 40 and 41, Lord Kerr says as follows. Various formulae have been employed to describe the nature of the similarity that is required. For instance, whether the purpose and essential characteristics of the two measures are the same, Palmazzani, or whether the role played by the provision in the procedure as a whole, as well as the operation and any special features of that procedure before different national courts, sustain or detract from the claim to equivalence, leves. Another criterion suggested is that the purpose and cause of action should be similar. Again, reference to leves. The latter part of this formulation prompted the statement by Lord Justice Buxton that the juristic structure of the two measures should be closely related. It is not clear, however, whether any or all of these criteria are indispensable requirements. As Lord Clyde observed in Preston No. 2, the requirement of similarity or comparability is an inexact one. It is unlikely that juristic structures of exactly similar type are required if by that term it is implied that the means of securing the right should be the same or directly analogous. If the essential characteristics of the rights claimed are identical or closely similar, it would be a curious result that equivalence should be denied simply because the legal means of obtaining vindication of the right asserted differed. On the other hand, if the juristic structures are the same, this might well be a good indicator that the principle of equivalence applies. And then carrying on the whole, therefore, there is much to be said for Lord Neuberger's view that the question of the required similarity and the criteria necessary to establish it in an individual case will depend on the context in which the application of the principle of equivalence is canvassed. It does not appear, however, that this issue has been directly considered by the Court of Justice, and on that account alone, a reference is required. So, putting to one side the reference made in that case, or the reference ordered in that case, it is clear that there are various different matters referred to in the various Court of Justice judgments that are said to be relevant to the inquiry as to whether one claim is materially similar to another for the purposes of the principle of equivalence. That list is unlikely to be a closed list, and no doubt context is one important matter when deciding what weight should be given to any particular item on the list in any particular set of circumstances. But despite the absence of any comprehensive cast iron statement of what similarity requires, In my submission, it is clear from a review of the cases, even the cases before you this afternoon, that the Court of Justice measures the notion of similarity very much in specifics. It does not take any form of a broad brush approach, but rather applies a consistently narrow approach. In my submission, there are four examples of this in the authorities bundle. The first is Palmazzani. My lady, that is in volume 3 of the authorities at tab 25, starting at page 891. Now, lady, if I could ask you to go first to page 901, paragraph 32, towards the bottom of the page. This was a case where what was in issue were different limitation periods, and various distinctions were drawn, both between claims for damages for late implementation of the directive in issue in that case, which was Directive 80/987, and on the other hand, between claims under the provisions of that directive once it had been implemented. So picking the judgment up at paragraph 32, as regards the question whether a time limit of the kind provided for by the legislative decree complies with the principle that it must be equivalent to the conditions relating to similar domestic claims, it should be noted that the National Court refers more specifically to the procedural rules governing applications for benefits submitted to the guarantee body under the legislative decree, actions for obtaining social security benefits other than pensions pursuant to Law 438, and ordinary actions for damages governed by Article 2043 of the Italian Civil Code. So pausing there, this was a situation where the court, in its reference at least, has suggested a range of similar domestic claims. And then over the page, paragraph 33 makes the point that ordinarily it is for national courts to identify the application of the principle of equivalence. The court then goes on to give to make some general observations, which I'll come to in a moment. But pausing there, one point made by Mr. Firth this afternoon was to the effect, well, when it comes to the principle of no most favourable treatment, one cannot find a judgment of the Court of Justice actually applying that principle or that proviso. It may well be that the most likely reason for that is in relation to the application of the principle of equivalence generally. It is a principle that the Court of Justice expects national courts to apply, because obviously they have the detailed knowledge which allows judgments to be made first in relation to similarity and then in relation to the application of the proviso, if that is necessary, on the facts of any particular case. But going to paragraph 34 of the judgment here, first, as Rosalba, Palmazzani and the Commission emphasise, the measures implementing the directive contained in the legislative decree pursue an objective that differs from that of the compensation scheme established by that decree. While the former aim to provide employees by means of specific guarantees of payment of unpaid remuneration with protection under community law in the event of the insolvency of their employer, the latter seeks, by definition, to make good to a sufficient extent the loss or damage sustained by the beneficiaries of the directive as a result of its belated transposition. And then at paragraph 36, since applications made in connection with the implementation of the directive and those made under the compensation scheme laid down by it differ as to their objective, there is no need to undertake a comparison of the procedural rules governing them. 37, for the same reason, that must also be true of actions under national law for obtaining social security benefits other than pensions. And then at paragraph 38, a further distinction is drawn in respect of the time limit provided under the provision in the Civil Code. The court said, as far as the ordinary system of non-contractual liability is concerned, it must be pointed out that unlike the procedures examined under paragraphs 34 to 37 of this judgment, that system is on the whole, in terms of its objective, similar to that introduced by Article 2.7 of the legislative decree, inasmuch as it is intended to guarantee reparation of the loss or damage sustained as a result of the conduct of the perpetrator. However, in order to establish the comparability of the two systems in question, the essential characteristics of the domestic system of reference must be examined. In that regard, the court does not have all the information necessary to determine more specifically whether an action for damages brought by an individual pursuant to Article 2043 of the Civil Code is capable of being directed against public authorities on the ground they have failed to act or have committed an unlawful act for which they can be held responsible in the exercise of their powers. It therefore falls to the National Court to undertake that examination. And then the court goes on, if the ordinary Italian system of non-contractual liability were to prove incapable of serving as a basis for an action against public authorities for unlawful conduct for which they can be held responsible in the exercise of their powers, and the National Court were unable to undertake any other relevant comparison between the time limit at issue and the conditions relating to similar claims of a domestic nature, the conclusion would have to be drawn, in view of the foregoing, that community law does not preclude a member state from requiring any action for reparation being brought within the time limit that was an issue in that case. So, my lady, what one sees there in relation to each of the options put before the court on that occasion, a very specific approach being taken to the notion of similarity. The same point appears in the Advocate General's opinion in this case. My lady, if you could go to page 911 in the report, which is part of the Advocate General's opinion, the material paragraphs are 25 to 27, and in particular, paragraph 27, this is the bottom of the right.
But what was the first paragraph you referred to?
25, my lord, which is first column on page 911, and then 27 is immediately adjacent to that second column of page 911, where the Advocate General says, a claim must be compared with a claim of similar nature, a procedural rule with a procedural rule of similar kind, and court procedure with court procedure of similar kind. Comparison must not be made between disparate claims or between rules dissociated from the corresponding procedure or which are subject to different procedures, for example, administrative procedures on the one hand and judicial procedures on the other. And so again, emphasising the specificity of the comparison that is required. My lady, the next case, which emphasises the same point, is Compass Contract Services, which is in volume 2 of the authorities at tab 17. And the report starts at page 647. This case concerned the comparison of, or the attempted comparison of different claims, both of which arose in the context of the payment of VAT. On the one hand, claims to recover overpaid VAT, and on the other hand, the ability under the VAT scheme for a trader to offset input tax. The conclusion, ultimately, was that there was no comparison for the purposes of the principle of equivalence between those different types of claim, albeit they arose in the context of the same tax. My lady, in terms of the judgment, if I could ask you to go to page 654, at the top of that page, paragraph 26, the court begins its examination at that stage, necessary to examine, etc. And then going down towards the bottom of that page, paragraph 31, the court identifies what it is that characterises the right to repayment. It says, therefore, it should be noted that the element which characterises such a right to repayment and from which it originates is an overpayment to the tax authorities by a taxable person of an amount of VAT in breach of EU law. It is specifically the fact that the VAT is not due which underlines the right to recover. And then the court continues at paragraph 36. By reference to the question of the right to deduct input tax, which it is considered from paragraph 32. At 36 it says, therefore, unlike the element characterising the right to repayment of overpaid VAT, the right to deduct VAT, which is a right inherent in the VAT scheme established by the common system of VAT, is based on the existence of a tax that is due. And so, based on that distinction, the court declined to regard the matters as relevantly similar for the purposes of the principle of equivalence. The same point is followed through at paragraphs 38 to 39 by reference to the difference in nature of the rights in issue, the objectives pursued, and so on. And finally, at 41, the conclusion stated there that there was no relevant similarity. And the final sentence of that paragraph, the principle of equal treatment, therefore, does not preclude those two situations from being treated differently as regards the time limits resulting from those transition periods. My lady, the next case I would like to take you to is EDIS, which you've already seen in part. This is also in volume 2 at tab 19.
Well, that's the Advocate General.
Sorry, yes, the Advocate General is there.
Yeah. The actual judgment is...
Yes. The bit that you might think counts is in volume 4. Perhaps I should take you to that first and I can leave the Advocate General. So yes, volume 4, which is the separate case, my lady. If you turn first to page 5 in volume 4, paragraphs 10 and 11 identify, this is again a case about limitation periods, they identify the different limitation periods in issue. So the first was a 3-year period under Decree 641 of 72, and the second was a 10-year period in relation to, under Article 2946 of the Civil Code. And then the judgment itself, you've seen the passage already, but I'll take you to it again if I may. Starting on page 12, paragraph 34. Paragraph 34 is the court's general statement of the principles of equivalence and effectiveness. And then paragraph 36, a further statement in relation to equivalence, a general statement, and paragraph 37 is by way of a more specific application of the principle of equivalence to these circumstances before the court. I say it is clear from paragraph 37 that the principle of equivalence is designed, what the principle of equivalence is designed to prevent is a situation where a claim arising from EU law is singled out for special treatment because of its origin. In the course of his submissions, Mr. Firth made great play of the fact that the Court of Appeal in this case had referred to the worst treatment in the context of the proviso about no most favourable treatment. My submission in due course will be that is simply a submission based on semantics rather than substance. And I say that is supported by the last sentence in paragraph 37, which you've already been taken to at some length already. But if you look at paragraph 37, thus, says the court, applying paragraph 36 of the case before it, community law does not preclude the legislation of a member state from laying down alongside a limitation period applicable under the ordinary law to actions between private individuals for the recovery of sums paid but not due, special detailed rules which are less favourable governing claims and legal proceedings to challenge the imposition of charges and other levies. And then here, the position would be different only if those detailed rules applied solely to actions based on community law for the repayment of such charges or levies. So one could say that last sentence again is describing a situation which might be described as a situation where community law claims get the worst treatment. But in any event, the point it is making is that if community law claims are set apart and then are subject to procedures that are less favourable to similar domestic actions, that is the situation in which the principle of equivalence bites and applies. May I also emphasise at this point, by reference to paragraph 36, and the statement in the final sentence in paragraph 36 of the no most favourable rules proviso, that there is no question there in the way in which the court formulates that proviso of any notion of exceptionality or specialty. The court simply states the proviso in clear terms, I say, to deal with a situation where the product of consideration of the which domestic law claims are similar inquiry is that there are two or more claims that can be regarded as relatively similar. In that situation, the application of the proviso has the effect that it is not a breach of the principle of equivalence if community law claims are treated equivalently to at least one of those similar domestic law causes of action. Of course, if the result of the similarity inquiry is that there is only a single domestic law derived claim that is similar, well then the proviso simply has no application to the circumstances of that case, in the same way as if the result of the similarity inquiry is that there is no domestic law claim that is similar. In those circumstances, the principle of equivalence itself has no application in those particular circumstances. But for the purposes of my present submission, the significance of the passage in Edis is that the court is looking very specifically in relation to the question of similarity. It is not taking a broad brush approach, for example, simply asking itself the question, is this a claim for the recovery of money that was not due? And so to that extent, taking an approach that is very different from the approach suggested by Totel in this appeal, which is that you can answer the question of similarity simply by asking questions like, is this an appeal against an assessment tax? The final of the four cases that I wish to take you to for the purposes of this submission is the judgment in Riemtsma. Again, you've been taken to this already, so I'll deal with this relatively briefly. My lady, it's in volume 3 of the authorities, tab 28. And the first page of the report is page 957. You have the circumstances of this case already. In particular, if within the report you go to page 966, paragraphs 13 to 15 summarise the circumstances that led to the proceedings. And then the second reference question on page 967 is the question that was material for present purposes. So that question, in general, is it possible to infer from the uniform community rules that the recipient of goods or services is the person liable for payment of tax to the relevant authorities? Is it compatible with those rules, and in particular with the principles of neutrality of VAT, effectiveness and non-discrimination, not to grant under domestic law to a recipient of goods or services who is subject to VAT and who is treated under national law as being subject to the obligations of invoicing and payment of the tax, a right against the revenue authorities to claim reimbursement in cases where tax that is not due is charged and paid. Our national rules, as interpreted by the national courts, under which a recipient of goods or services may bring an action only against the supplier of the goods or services and not against the revenue authorities, despite the existence of a case of substitution of that kind under domestic law in relation to direct taxes, where both parties, the withholding agent and the taxpayer, are entitled to apply to the revenue authorities for reimbursement, contrary to the principles of effectiveness and non-discrimination in the matter of reimbursement of VAT collected in breach of community law. And, my lady, you've already been taken to the material passages, first in the opinion of the Advocate General, paragraphs 93 to 94, and then within the judgment of the court, paragraphs 43 to 45. For your note, I won't take you back to the Advocate General, you've seen that. Paragraphs 93 to 94 of her opinion, pages 999 to 1000. The judgment of the court, is page 975, if you'd be good enough to go there, paragraph 43, 44, and then over the page 45. Now, for the purposes of my present submission, regardless of whether this case is interpreted as addressing only the specific circumstances before the court, or as providing a wider statement that direct and indirect taxes are not similar types of charge, it is clear that what the court is doing is taking a very narrow approach to similarity. There is thus great emphasis on the need to compare like with like. Again, in passing, while you have this case open, one point made for Totel this morning, again in the context of the no most favourable treatment proviso submission, was that in this case, it was said, the claimant must have relied on a direct tax comparator because the position in relation to all Italian indirect taxes must have been the same as in relation to VAT. So far as I can see from the report, there is simply no statement either to support that proposition or to refute it. And so it's simply a matter of speculation whether that was the reason why the claimant in this case identified the direct tax claim as the relevant similar claim or not. I say simply one can draw no inference from the absence of information one way or the other. But coming back to my submission about the approach that the Court of Justice takes to similarity, again, each of those four cases shows the court drawing fine distinctions between different types of claim, between different types of right, between different types of claim arising in the context of the same tax scheme. By contrast, the cases where the Court of Justice has been satisfied that the comparator's claim for it was a similar claim have been relatively few, and they have often been cases where the comparator causes of action were addressed to materially the same matter. And in relation to this submission, could I take you first to a case you were taken to this morning, the Transportes Urbanos judgment, which is also in volume 3 of the authorities, this time, my lady, at tab 30, starting at page 1025. And going to the judgment of the court, the context for what the court decides is set by paragraphs 15 to 16. Paragraph 15, my lady, starts at page 1043 and says this. In its order for reference, the Tribunal Supremo recalls that according to the contested case law, the bringing of an action for damages against the state on the basis of the unconstitutionality of legislation is not subject, unlike the same action based on the incompatibility of that legislation with EU law, to any condition requiring prior exhaustion of remedies against the challenged administrative measure based on that legislation. And then paragraph 16, the reason for the difference in treatment between those two actions arises from the differences between the actions which can be brought against an administrative measure, according to whether those actions are based on the incompatibility of that measure with EU law or on the breach of the Constitution by the national legislation pursuant to which that measure was adopted. So that identifies the distinction between the claims. So far as the court's reasons, turning to page 1046, paragraph 33 paragraph 33 and paragraph 44 is a relatively standard statement by the court of the principle of equivalence. In his submissions this morning, Mr. First placed particular reliance on paragraph 36 on page 1047. In my submission, one can't look at that paragraph in isolation. It's the beginning of a run of paragraphs that goes down through the rest of the page and ends up paragraphs 43 to 45, which are the conclusions, in the course of which the court refers to various different matters for the purposes of its inquiry as to similarity. At paragraph 43, which I say is the paragraph where the conclusion starts, the court says, it appears from the foregoing considerations that in the specific context which gave rise to the case in the main proceedings, as described in the order for reference, the only difference between the two actions referred to in paragraph 35 of this judgment is the fact that the breaches of law on which they are based are established in respect of one by the court in a judgment given pursuant to Article 26 of the treaty, and in respect of the other by a judgment of the Tribunal Constitucional. This fact alone, in the absence of any mention in the order for reference of other factors demonstrating that there are further differences between the action for damages against the state actually brought by Transportes Urbanos and the action which it might have brought on the basis of a breach of the Constitution established by the Constitutional Tribunal, cannot suffice to establish a distinction between those two actions in the light of the principle of equivalence. In that situation, the two above-mentioned actions may be regarded as similar for the purposes of the case law referred to in paragraph 35 of this judgment. And so the only material difference, said the court, was that one was based on Spanish law and the other claim was based on EU law. And so to that extent, so far as the court was concerned, this was an almost textbook instance of a situation where the principle of equivalence would operate. A similarly narrow situation was considered by the Court of Justice in Leves. My lady, that's file 2, tab 21, judgment starting at page 785. The equivalence argument in this case arose in rather specific and special circumstances, but I say it's a further example of a very narrow field of comparison. My lady, as this court will be well aware, the judgment in Leves concerned a challenge to the 2-year cap on compensation in employment tribunal proceedings under the Equal Pay Act, on the ground that that limitation on recovery was contrary to the principle of effectiveness. However, the United Kingdom government's argument, or part of its argument, was that the availability of a county court claim met the requirements of effectiveness by providing an opportunity for an employee to obtain damages that would extend beyond the 2-year cap period provided under the tribunal procedures. And my lady, that point is apparent if you go to page 796. On that page, at the bottom of the page is paragraph 34, and the material paragraphs are 34 and 35. At 34, the court says, the answer to the first question must therefore be that community law precludes the application of a rule of national law which limits an employee's entitlement to arrears of remuneration or damages for breach of the principle of equal pay to a period of 2 years prior to the date on which the proceedings were instituted, there being no possibility of extending that period, where the delay in bringing a claim is attributable to the fact that the employer deliberately misrepresented to the employee the level of remuneration received by persons of the opposite sex performing like work. Then under the heading question 2, paragraph 35, the court says this: in the light of the reply to the first question, there would be no need to address the second question referred by the National Court insofar as it concerns proceedings brought before the Industrial Tribunal. However, the United Kingdom government argues that on the facts, Mrs. Levitt could, in proceedings before the County Court, successfully have claimed full compensation for the damage suffered on account of the fact that her employer's deceit had prevented her from bringing a claim under the Act. She could have relied in such proceedings both on the Act and on the deceit committed by her employer, and the rule at issue would not have applied. This then resulted in the court comparing, or rather undertaking a comparison of the circumstances applicable to a tribunal claim and the procedures applicable in a county court claim. See, for example, what is then said at paragraph 36 of that judgment. And so the equivalence question in this case entailed a comparison of two different means, effectively, of enforcing what was in substance either the same or a very similar right. I say that is underlined by what the court says at paragraphs 50 to 51. My lady, paragraph 50 is on page 800. Court says there, if it transpires on the basis of the principles, sorry, I should say, this morning you were taken to paragraph 49, which identifies the fact that the tribunal that made the reference, in the course of the reference, had identified a range of candidates for the similar action purposes. And then paragraph 50, the court says, if it transpires on the basis of the principles set out in paragraphs 41 to 44 of this judgment, that a claim under the Act which is brought before the county court is similar to one or more of the forms of action listed by the National Court, it would remain for that court to determine whether the first mentioned form of action is governed by procedural rules or other requirements which are less favourable. On that point, it is appropriate to consider whether, in order fully to assert rights conferred by community law before the county court, an employee in circumstances such as those of Mrs. Leves will incur additional costs and delay by comparison with the claimant, who, because he is relying on what may be regarded as a similar right under domestic law, may bring an action before the Industrial Tribunal which is simpler and, in principle, less costly. You were also then this morning taken to paragraph 53, which again, of course, is contingent upon the assessment of the domestic court. One point that was made this morning in relation to paragraph 53 is that it was said there was nothing in paragraph 53 that refers to any application of the no most favourable treatment proviso. In my submission, that's a misunderstanding of the court's judgment when it is considered as a whole. Paragraph 53 is plainly premised upon what is said at paragraph 50, which I've already read to you. And paragraph 50 itself, when it invites the National Court to undertake the comparison exercise, specifically refers to the principles set out at paragraphs 41 to 44. And, my lady, if you turn back to page 798, where you find those paragraphs, one sees specifically at paragraph 42 reference to the no most favourable rules proviso. And so the court is not saying in Leves that for the purposes of considering the similarity of the range of claims advanced as candidates by the referring tribunal, that the no most favourable rules proviso has any application to play. Rather, it is making the point, in my submission very clearly, that that proviso clearly will have a role to play if the outcome of the assessment of similarity is that there are in fact two or more relevantly similar domestic law derived proceedings. My lady, I think this morning there was some question as to how the no most favourable treatment proviso might apply in a situation where there were two or more relevant domestic law claims. In my submission, it will be applied in a relatively straightforward way. The method that a court might adopt when applying the principle of equivalence might firstly be to identify candidates for the relevantly similar domestic law claim. At that stage, it is likely that a court might be invited to cast the net wide when it comes to identifying candidates and to consider more than one claim. It will then assess those candidates in order to reach a decision as to whether any or more of them are relevantly similar for equivalence purposes. If the outcome of that assessment is that more than one domestic claim is similar, well then it will then need to decide whether the treatment of the relevant EU law claim is equivalent to any of those domestic similar claims. If the answer to that question is yes, then there is compliance with the principle of equivalence. The fact that there is, in addition, a further domestic similar claim, which has the benefit of a more favourable procedural rule, is neither here nor there, and that is precisely what the no most favourable treatment proviso means, and precisely the effect it is intended to have. If one simply looks at the language in which that proviso is described by the Court of Justice, again, on occasion after occasion. But in any event, Leves, one sees there, again, a situation where equivalence was being directed really towards different procedures, each of which was directed towards obtaining precisely the same objective for the claimant. A similar situation, I say, was before the House of Lords in Stringer, which you've been taken to already, but I'd like you to go back to. That is in Volume 1 of the authorities, tab 5, starting at page 277. Again, as already explained in submissions this morning, that case concerned the routes that were available to an employee to claim holiday pay that was due under the working time regulations. And the argument before the court turned on whether or not the procedure provided under the working time regulations was an exclusive procedure, or whether holiday pay that was due under the working time regulations also fell within the definition of wages for the purposes of a claim in relation to a deduction from wages under the Employment Rights Act. If the answer to that question was yes, as a matter of statutory construction, then the employee had the benefit of a significantly more generous recovery scheme, because as was explained in relation to a claim for unpaid wages, if there is a series of deductions, the 3-month time limit for bringing a claim only ran from the date of the last in the series. So the employee could thereby reach back. There was no similar series rule that applied under the working time regulations. So that was the situation before the court. The issue before the House of Lords turned primarily on whether or not unpaid holiday pay fell within the scope of the definition of wages in the 1996 Act. And on that, the House of Lords concluded, yes, one sees this from the headnote on page 277. The definition of wages in section 27.1 of the 1996 Act was sufficiently wide to be capable of referring to a payment due under regulations made after the passing of the Act, that claims for payment in respect of periods of annual leave under Regulation 16 of the Working Time Regulations, and claims for payment in lieu of leave on termination of employment under Regulation 14 were claims for holiday pay within section 27 of the 1996 Act, that accordingly the employee had been entitled to complain under section 23 of the Act of unlawful deduction, and that conclusion was supported by the community law principle of equivalence, since payments due under regulations 14 and 16 were similar to the many other types of payments covered by section 27, and accordingly, if they did not fall within Section 27 and thus benefit from its more favourable limitation provision than that in Regulation 30, the principle would be infringed. And so, you see there that the equivalence issue firstly was subsidiary, but actually was deployed largely as an aid to the construction of the meaning of the term wages in the 1996 Act. But as in Leves, this was a situation in which the claim was the same and the equivalence point arose because there were two procedural routes by which that claim could be pursued. And I say this is clear from passages in two of the speeches. Firstly, Lord Walker on page 297, paragraphs 61 to 62. Um, 61 is a reference to the decision in Preston, which I'll come to next. And then 62, Lord Walker says this, in these appeals, however, the parallel between the statutory right to paid annual leave and a contractual right to holidays with pay is, to my mind, much clearer and closer. It is not less close because of the Working Time Directive's emphasis on health and safety at work. Similar thinking has for many years informed the approach of responsible employers in framing contractual terms of employment. Moreover, in each case, the remedy would be an order for payment of the liquidated sum due. In concluding that the appeals on the outstanding issue should be allowed, I would therefore base my conclusion both on normal principles of statutory construction and on the principle of equivalence. On this issue also, I would set aside the order of the Court of Appeal and restore the order of the Employment Appeal Tribunal. And to like effect, Lord Neuberger, paragraph 78 to 79 on page 300, my lady. So paragraph 78, for the reasons so far given, it seems to me that on purely domestic legal principles, the appellants are correct in their contention that payments due under regulations 14 and 16 fall within section 27 of the 1996 Act. Then I'm going to say, however, if the contrary had been arguable, or even probably right, if one confined oneself to domestic law, I would still have found for the appellants on an additional ground persuasively advanced by Mr. Jeans, Queen's Counsel for the appellants, based on the EC law principle of equivalence, which is then described. In paragraph 79, the issue which arises in the present appeal is whether there are claims under section 27 which are similar to but benefit from more favourable limitation periods than claims under regulations 14 and 16. If such letter claims do not fall within section 27, if the answer is in the affirmative, that would reinforce the conclusion. Indeed, it would provide an additional reason for concluding that claims under regulations 14 and 16 did fall within section 27. Otherwise, the United Kingdom will be in breach of its European treaty obligations. So, again, although the principle of equivalence was clearly relied on by the House of Lords in that case, it was relied on in rather, again, singular circumstances and relied on for the purposes of addressing a situation where effectively the employees were in a position where either of two procedural routes were available to them for the purposes of recovering precisely the same amount of money. While you have this page open, could I make two further points in relation to the speech of Lord Neuberger? The first, in respect to paragraph 79, I think it was suggested in passing this morning that paragraph 79 might be some form of reformulation of the principle of equivalence. In my submission, that is a significant over-reading of the paragraph. What Lord Neuberger at this stage of his speech is doing is dealing with, as it were, a secondary argument advanced by the appellants in that case, identified the relevant EU law principle of equivalence, and is simply there in paragraph 79, providing a working summary of that principle for the purposes of dealing with the case before him, certainly not purporting in any way to depart or, for that matter, to do anything other than apply the way in which that principle has been consistently formulated by the Court of Justice. The second point is in relation to paragraph 81, which is the reference to exceptional or unusually beneficial rules. Now, you have my submission in relation to the no most favourable rules proviso in relation to this paragraph of Lord Neuberger's speech. In my submission, as the Court of Appeal did in this case, one needs to understand the point that is being made by looking at the paragraph in context. The proposition that Lord Neuberger is advancing is specifically tied to the judgment of the Court of Justice in Leves at paragraph 42, and that judgment in Leves, paragraph 42, as you've seen, is in turn specifically tied to the relevant paragraph 36 in Edis. That being so, again, in my submission, it is an over-reading, a reading out of context of paragraph 81 to suggest, as the appellant does in this case, that it is applying some form of reformulation to the no most favourable treatment proviso. And certainly, if one were to read that paragraph in Lord Neuberger's speech as attempting to do that, there would certainly be no basis in case law for that reformulation. The case law cited by Lord Neuberger would not support a reformulation of that principle. And in those circumstances, it would be very surprising if that is, in fact, what Lord Neuberger was either seeking to do in paragraph 81, and even more surprising if that's what he achieved. The final case in relation to my survey of cases where effective equivalence has been relied on, but in very, very limited circumstances, is the judgment in Preston, referred to by Lord Walker in his speech in Stringer. Preston, my lady, is in the same authority's volume. It's tab 11, starting at page 477. And this was one of the claims relating to the part-time, the access to pensions issue for part-time workers. I need two passages to go to. The first is in the speech of Lord Slynn, starting at page 491, paragraph 14, under the heading Similarity. I won't read the whole passage, but could I draw your attention in particular to what is said at paragraphs 21 to 23, at the bottom of page 492, top of page 493. It's this. I accept there is force in the respondent's arguments and that one should be careful not to accept superficial similarity as being sufficient. It is not enough to say that both sets of claims arise in the field of employment law, nor is it enough to say of every claim under Article 119 that somehow or other a claim could be framed in contract. I have, however, come to the conclusion that these arguments should not prevail. The essential matter here is that monies have not been paid to the trustees of a pension fund to purchase pension rights on eventual retirement or on reaching the prescribed age. A successful claim under Article 119 obtains retroactively full access to the scheme, so that the necessary contributions to obtain the appropriate pension rights for that individual have to be paid. A claim in contract would be for damages for the failure to pay those sums to the trustees, leading to a total or in some cases a partial loss of the pension rights. In form, they are plainly different, but in substance, the eventual benefit to the employee is sufficiently similar for present purposes. To adopt the words of the Court of Justice, on the reference in that case, the right of action available under domestic law is a domestic action similar to proceedings to give effect to rights conferred by Article 119 of the treaty. This is so whether the contractual term is express, implied, or imposed by statute. Accordingly, resisting the temptation to say simply the is a claim under Article 119 and under the 1970 Act sui generis, I would uphold Mr. Panic's submission that a claim in contract may provide a sufficiently similar comparison. That was Lord Slynn. The other speech to look at is the speech of Lord Clyde. My lady, if you go to page 496 first, which is immediately before the speech of Lord Clyde, you will see that the other three members of the House, Lord Gough, Lord Nolan and Lord Hope, all agreed with Lord Gough and Lord Nolan agreed with Lord Clyde, but they all joined in the same conclusion on the facts of the case. Lord Hope agreed with Lord Slynn. So in terms of majority-minority, in terms of reasoning, Lord Slynn was in the minority, although, as I say, all members of the House agreed on the disposal of the case.
Sort of a mixture of things they seem to have agreed with. But
Yes.
anyway, your point, there was enough people agreed with Lord Clyde to make it worth looking at what he said.
Well, yes, indeed, more than enough people agreed with Lord Clyde. But the point I take you, the reason I've taken you both to Lord Slynn and to Lord Clyde, first I should show you the passage in Lord Clyde's speech, is paragraphs 43 and 44. Now, paragraph 43, again, I won't read this, but Lord Clyde disagrees with Lord Slynn's conclusion that one can compare as relatively similar the contractual claim with the claim under the Equal Pay Act, the claim based on Article 119.
It's very strange, given that the Equal Pay Act actually implies a term into all contracts of employment. So it's quite interesting.
Anyway, be that as it may, in the end it didn't matter in terms of the outcome, but paragraph 44, Lord Clyde goes on, but it may be that this is to apply too strict or precise a standard for the comparison. Certainly the Advocate General was able to conceive that a comparator might exist, and he stated, quotes the Advocate General, then Lord Clyde continues, if one adopts a broad view of the exercise of comparison, I can see that an action for breach of contract might well be accepted as an appropriate comparator. To use the language of my noble and learned friend Lord Slynn, whose speech I've had the advantage of reading in draft, the suggested action for breach of contract may provide a sufficiently similar comparison. But even if by that standard the principle of equivalence can be satisfied, I do not consider that the applicants should succeed. And this is the point on which all members of the House agreed. On the basis of the wider approach to the problem of comparison, which my noble and learned friend Lord Slynn has adopted, I am in full agreement with him that the rules of procedure for a claim under Section 2.4 of the 1970 Act are not less favourable than those which would apply to a claim for the breach of contract in the circumstances of the present case. I would accordingly agree with the conclusion which he has reached in the form of order he proposes. The point, for present purposes, is paragraph 44. Now, even though Lord Clyde described Lord Slynn's approach as a broad approach to comparison, if one looks at Lord Slynn's approach on its own terms, it's actually a very restricted approach to comparison, in that he only concludes that they are relevantly similar causes of action because he concludes that effectively they're after precisely the same thing, whether it be pursuant to an express term of a contract, an implied term, or a term implied by contract. And so even on Lord Slynn's analysis, it's not really a wide comparison, it's a very narrow comparison, and a situation as in Levez and as in Stringer, where effectively the same thing, respectively compensation for unequal pay in Levez, for non-payment of holiday pay in Stringer, and for the absence of a proper pension contribution in Preston, the same thing could be obtained by different claims depending on whether the right relied on arose under EU law or English law. And I say that those cases, again, further underline the conclusion that the Court of Justice takes a very limited approach to the notion of comparison, a very strict approach, and not an approach that is consistent with the much wider principles advocated for Totel in this appeal. My lady, those are the general submissions on the principle of equivalence. Could I turn now to the specific submissions that the Commissioners made? And the first is that there is no appropriate comparison between VAT and other tax claims. If I may, I'll make a start on this. I may not finish it this afternoon, but I'll certainly make a decent start at it. My lady, this submission rests in part on the judgment of Mr. Justice Moses in the Marks and Spencer claim. That judgment is file one of the authorities at tab 9, starting at page 399. The context for the challenge was the well-known modification, shortening of the limitation period for claims for repayment of VAT, a change that spawned so much litigation up to and including the Littlewoods claims themselves. Now, my lady, careful readers of the bundle may have noticed that the pages of this report are out of order. It's sort of an Eric Morecambe version of the bundle. All the right pages are there, but not necessarily in the right order. The part of Mr. Justice Moses' judgment that deals with equivalence is paragraphs 56 to 62. Those are the pages that are out of order and actually start at page 445 of the bundle, which is at the very end of the report. But once you've located those pages, it doesn't matter that they're out of order. My lady, just making submissions by reference to those his reasoning. At paragraph 56, the starting point for Mr. Justice Moses is the statement of principle in EDIS. So he refers to paragraph 36 of the judgment in EDIS and then paragraph 37. Then at paragraph 57, he identifies the claimant's contention in relation to comparable claims. He says here, the issue in relation to this ground of challenge turns on the appropriate comparator. Marks and Spencer points out that the limitation period in respect of other taxes, such as income tax and capital gains tax, is longer. The comparison, it asserts, cannot be confined to VAT, but should cover all claims for repayment of taxes which were not properly levied. The principle depends upon there being an appropriate comparator, and if it is confined merely to VAT, that comparison cannot take place. Then at paragraph 58, there is reference to the judgment in Palmisani, and then paragraph 59 continues the reference to Palmisani, and the quotations from Palmisani are firstly from paragraph 38, which is about 2/3 of the way down the page, and then from paragraph 39, which is at the bottom of the page. And again, maybe you recall that Palmisani was the case in which the Court of Justice was presented with a situation where various different claims were being advanced by the referring court as possible similar domestic-based actions. And then Mr. Justice Moses' reasoning is at paragraphs 61 and 62. 61, in my judgment, no comparison can be made with other types of tax, such as income tax payable in respect of an individual's profits, or the tax on a document imposed by stamp duty. Other forms of indirect taxation, such as excise duty, are wholly different types of tax. It seems to me that the jurisprudence of the European Court of Justice, exemplified in EDIS, requires a comparison between the approach of a member state to the recovery of tax charged in breach of community rules and the recovery of the same tax in breach of domestic rules. Any wider inquiry will invite unnecessary argument as to whether there is a true comparison. There is no need to widen the range of inquiry if it is recalled that the need for making comparisons stems from the principle of equivalence, which is designed to avoid infringements of community law being dealt with in a less favourable way than infringements of domestic law. The need for the comparison was recently emphasised in the judgment in Koji, quotation, such repayment must be ensured in accordance with the provisions of its national law, on condition that those provisions are not less favourable than those governing similar domestic actions. The principle is designed to protect community law rights. Adequate protection is afforded by focusing upon the way a member state deals with the same tax in a domestic as opposed to community context. That was Lord Justice Moses' reasoning, and that reasoning and that conclusion was approved by the Court of Appeal in the Littlewoods litigation. And the judgment there is tab 8 of the same file, my lady, starting at page 329. Again, if I may, I'll deal with this case as well before I finish. The context, as the court is probably well aware, claims for interest on overpaid VAT made on the basis that the interest payable under the VAT Act was not sufficient to meet the requirements of EU law. The equivalence point arose on the premise that the statutory provisions under the VAT Act did not meet the requirements of EU law, and in the context of an argument that in those circumstances the provisions of the Act should be disapplied, but only to the extent of permitting a Woolwich-type restitution claim, that is to say, a claim for restitution following an unlawful demand, because, said the commissioners, that cause of action was the one that best gave effect to the San Giorgio right. And one sees the passage relating to that issue starting, this is just for your note, my lady, paragraph 119 on page 372. That's where consideration of that issue starts, which is issue 3B in that appeal. The submission is at paragraph 134, page 377. And the gist of that submission for Littlewoods was that it would not be right to disapply the Act only to the extent of a Woolwich-type restitution claim, because that would put a claim for interest on an overpayment of VAT, the EU law-based claim, in a different position to a claim for interest on overpaid direct tax, which is a comparable English law claim. The point being, of course, that such claims in relation to in relation to the domestic law claims, there was no doubt that a restitution claim could be made either on a Woolwich basis or on a mistake-based restitution claim basis. The response starts within paragraph 134 and goes on to 135. It's 134, a line above letter H towards the right-hand margin. We are not persuaded by this. We are not persuaded by this. As Mr. Justice Moses held in Marks and Spencer, the principle of equivalence has been stated in a tax context to involve a comparison of the treatment of infringement of EU law and domestic law with respect to the same kind of charges or dues. That's the reference to EDIS. In Littlewood's ECJ, the Court of Justice received submissions from the Commission and a number of member states as to what the relevant comparator should be. The Commission argued for a general comparison with other taxes, whereas the UK, Netherlands and France said that the comparator should be other indirect or similar taxes. In its judgment at paragraph 27, the Court of Justice stated that the comparison should be with similar claims, which in the context of this case, we take to mean claims for repayment of domestic VAT. So that was the Court's response on that point, upholding and endorsing the conclusion reached by Mr. Justice Moses. My lady, I need to go next to the Court of Justice judgment and then to make short submissions on this point. And I suspect...
Let's be clear, the Littlewoods case has been through many levels, and
yes,
including us. Was that point never sort of examined again at any level?
No. You would have noted, my lord, that this was issue 3B in Littlewoods. It only arose if the conclusion had been reached that the VAT Act provisions on interest were inconsistent with EU law. The conclusion reached by this court on the appeal was that the VAT Act provisions were consistent with EU law, and so this was one of the issues that fell away. And so now is marked in the box marked interesting but not subject to determinative recognition. Subject, of course, to further appeals in other tax cases. But if that's a convenient moment, I'll pick it up again tomorrow at 10:30.
That's a very convenient moment indeed, Mr. Sturgeon. We'll look forward to hearing from you at 10:30 tomorrow morning.